little of what the judges are saying, which is probably a good thing. Last year there was or earlier this year probably, there was a conference at the Supreme Court, and the senior puisne judge, Justice Qazi Faizisa, asked a question. He said, how many of you in the room, and it was a room full of people, lawyers, are satisfied with the justice delivery system? And not one person stood up. And so that's the scale of the challenge that faces the litigation practice right now. All of us who are practitioners, whether as judges or lawyers who appear in courts, understand that the system is not delivering and something radical needs to happen given the growth in population, given the number of cases that are growing. It's just the workload is such that we keep talking about pendency. In Islamabad, which is a very small place, there are 17,000 cases pending in the High Court. There are 50,000 cases pending in the district courts. And that's just too many cases. So we've over the last year, we've tried to reimagine service delivery at our court. We've put up a paper which is on the website of Islamabad High Court, which flags 12 or 13 issues that we need to focus on. The analysis was that we are a post-colonial state and a post-colonial judiciary, which is just not service-oriented right now. And it's the same model that we continue to dispense justice through, which causes delays and needs to be fixed. We get a lot of flack for, I don't know, in the rule of law index being 130th or 127th or whatever, and every time that report comes out, everyone says, look at these judges, they're the ones to blame. But sitting as judges, at least at the High Court level, there is a failure of the governance system. The same failure mars the court systems as well. And when it comes to the state, it's all of the state's governance creating problems between the state and the citizens, which is then creating a lot more litigation. And it's just hard to handle. Up until the time that I was appointed as a judge, I never realized that the most pressing challenge for a judge was time. There is just too much work. There is too little time to do it. There isn't enough help when it comes to research, when it comes to looking at precedents from other jurisdictions, coming up with meaningful opinions. We've got 3 or 4 kinds of audiences. We've got the Supreme Court, which is the appellate court. So we've got to write an opinion in a form that will be understood by the appellate court as to why we are doing what we're doing. Obviously, there are the parties before you. You decide something, you decide for them, so they should understand what you've decided. Then you're a high court, you're laying down precedents for the district courts and all courts. So your reasoning has to be detailed enough. There have to be practice guidelines within it so that the district court understands. And then obviously you're writing for public at large as well. So the amount of work is just, the magnitude is such. If there are 30 cases fixed before a high court judge in a single sitting, which is generally the lower standard in our court, which is a lot less than what I understand is in the Lahore High Court and other bigger courts, it's just not possible to meaningfully listen to 30 cases in 2.5 hours. It's simply not possible. It's not possible humanly to write more than 3 or 4 decent judgments a day. Like even if you include weekends, you'll have to decide, you'll have to record arguments, you've got to give your own reasoning. It's a precedent, you've got to think of things. So the biggest challenge, at least for me personally, is that you just don't get enough time to think through the issues, to give the kind of sophisticated reasoning that we should be giving at the High Court level at least. So there are various things that we're trying to do. we need to revamp the manner in which the court is structured. There is a lot of administrative work that's not getting attention. The Chief Justice's office will have to be revamped. The senior civil judges in the district courts, the district judges, the kind of administrative functions that they have, there isn't enough thought going into that. So as an organization, we're just not geared towards service delivery. That's just one thing. Our HR management really suffers. There are evaluation systems, but performance evaluation, performance management, together with how you're going to resource courts, how you're going to promote people, how you're going to train them in various specializations, there is no effective system. There are other organizations in the country that are doing a much better job than the judiciary, so that's part of what we're focusing on. We've got ChatGPT, other AI features coming in, and we're not even digitized yet. So digitization is a huge challenge. We have to go that way. There is no option, and we're lagging behind by like 10 years. So that's another thing we're trying to do. Case management, there is no case management system right now. The response is generally arbitrary. You sit together and you say, okay, too many cases from 2012, for example. So we say, okay, the next 1 year, we'll wipe out all cases 2014 and before. But that's not really a 5-year plan. It's not a 10-year plan. It's not a 1-year plan for the judiciary. So that's it. There has to be a plan for where we expect the judiciary and the justice system to be 10 years from now, and then work backwards as to how we're going to get there. So that's on the list. So backlog management is a huge challenge, and that challenge will not be met till the time that the inflow doesn't limit itself. And for that, obviously, there is the whole ADR, which is what this conference is all about. In Islamabad, I believe somebody spoke about Islamabad as well this morning. So we now have rules. We've got trained mediators who've been notified, mediation accreditation rules for mediation centers. So that's part of the process. We've set out practice guidelines, and we've issued guidelines for district court judges, where in each and every cases you're kind of making sure that parties are encouraged to go into mediation if that is something that can happen. So ADRs are part of the plan. Then limine control is another device, and costs. And I was asked to speak about a judgment that I'd authored on the cost system. We've got a Cost of Litigation Act in Islamabad, and that was not being effectively implemented, so we put out a judgment. Thankfully, this job is not an elected job, otherwise I would have been booted out of my job in Islamabad based on that judgment. But essentially the law says this is a complete indemnity jurisdiction. The loser will pay for the costs of the winner, the entire legal cost. So there is a judgment with practice directions now. Based on that, we've also framed rules which are before the Rules Committee of the High Court, and hopefully there'll be a standardized practice. Right now, it depends on one judge to the other as to what their approach to costs is, but hopefully once the rules come in, irrespective of what court you were before, is going to issue costs, and that's the only way really to ensure that when a client comes to a lawyer, they'll give a rational, objective opinion as to whether or not there is merit in the case. And if there isn't merit, then you don't come into the court system, because if you do, then there will be consequences. And right now there are no consequences, which is why a lot of frivolous litigation comes to courts. So those are just some of the things that we're trying to do. Criminal justice, equally dire situation, whether it is at the bail stage or it's at the evidence stage. The manner in which I'm sure the prosecution and police authorities are as challenged as the court systems are in terms of resources, in terms of what should be done, but a huge bunch of the people in jails are under trial prisoners, not those who've been convicted. And that's a big problem. So when we look at the criminal justice system, there is very little, and again, courts get a lot of flack for releasing people 10 years later, maybe, but the investigation and the prosecution is pretty weak. And ultimately, a court will only decide based on the record. And if the record is such that there is no chance of conviction, then people are right to criticize and say, why have you held up somebody for 10 years? But so there are challenges there, and the judiciary will need to work with the executive to come up with and ensure that the investigation and the prosecution stages are taken care of in a manner that even in cases where there should be a conviction, the record reflects and enables a court to dispense justice in accordance with the facts and the law. So those are just some of the things that we're doing at the High Court. We'll hopefully order some kind of a diagnostic analysis of some of these components, and based on whatever data we get, then we'll kickstart this process. So I'll stop here. Thank you.
Thank you, Mr. Justice Sattar. I just have a couple of questions arising out of that. You stated that the most pressing challenge was time. I just wonder, there appears to be a significant number of cases that are issued. In the United Kingdom, there is quite a high issue fee, court fee, that has to be paid on issue of a claim. And for many claims, that will be above £10,000. So that obviously deters quite a number of litigants from actually issuing a claim, and they'd rather often look at mediating or other forms of ADR rather than issuing the claim. I just wanted to know if that would be a possibility in terms of the court fee, because is it right that the court fee is quite low?
Well, court fee is low. There is a balance that we'll have to strike, at least in Pakistan, because we are a poor country, and the court fee, speaking for myself, cannot be such that it becomes a hindrance to access to justice. So we've thought about some of these things as well. Court fee can be rationalized, but it's equally important to ensure that once somebody comes in, they've applied their minds to the merit of their case. And you get legal advice, and part of that legal advice is that, there is a 50% chance of losing the case. Let's try mediation. Or there is a 70% chance of losing the case, which will then mean X amount of litigation cost. So yes, I think court fee can be looked into, but for us, it'll have to be balanced out. Some of the people who come into the court system cannot afford lawyers. So the nature of the population and our consumer is such that putting a high ticket to them coming into the court system might breach their constitutional right to access to justice.
Thank you. I wonder if now we can hear from Mr. Justice Shah.
Bismillahirrahmanirrahim. Assalamu alaikum. Thank you, Maria, for inviting. Keeping in view the urgency regarding the resolution of commercial disputes, Khyber Pakhtunkhwa Resolution of Commercial Dispute Act 2022 was promulgated on 31st of August 2022. Under Section 3 of the said Act, commercial court were established, and High Court Peshawar in December 2022 transferred the entire commercial cases pending in various courts of the KP to these commercial courts, followed by a workshop held in the Khyber Pakhtunkhwa Judicial Academy, wherein judicial officers, lawyers, members of the legal fraternity, officials of Trade and Commerce Department, representative of the chamber, Sarhad Chamber of Commerce and Khyber. They participated, they remained there. Training was also provided to the administrative staff of these commercial courts. So far as the SAID Act provides for the appeals against the decision of the commercial court, Section 8 provides that before the appellate tribunal constituted under Section 8. And Section 12 also provides for an oversight committee to look into the matters of the commercial courts. And it's important to note that Section 14 of the SAID Act provides for referral of the matters before the commercial court and before the appellate tribunal to the alternate dispute resolution in line with Section 89A of the Code of CPC. It is important to note that keeping in view the importance and resolution of these commercial matters, the High Court has constituted a committee to look after the entire cases. Besides this, it is worth to note that the Arbitration Act was enacted in the year 1940, whereas in the year 1901, this very remedy was provided by the Frontier Crime Regulation, which was enacted, which was for the first time codified. The Jirga laws were codified to that very act in 1901. And under Section 8 and 9 of the same regulation, the inhabitants used to file their application before the political agent for the resolution of their criminal and civil disputes. The political agent used to frame the questions and refer the matter to the Council of Elders for its decision. And after collection of the evidence and appreciation of the same, they used to pass an award, which in turn used to be placed before the political agent for his decision. Thereafter, if objections were there, he used to decide those objections and award would attain finality, which was appealable before the Commissioner FCR and further before the FCR Tribunal. So, while giving the brief history of the resolution of the matters through Council of Elders, that was customary and in the blood of that very region, and still that is there. With the enactment of new laws, a provision has also been provided that let all the matters pertaining to civil dispute between the tribes be decided through alternate dispute resolution, which in our term we call it a jirga, constituted by the concerned authority and comprising of the elders of that very tribe or society. Besides, all these commercial courts were connected through Skype and Zoom. If a witness is at Karachi or abroad, arrangement can be made for recording his evidence for the swift resolution of the matter between the parties. Let me inform this House that Peshawar High Court, in the case of Muhammad Isrars, rendered a judgment through which the need for providing video link facilities across the province was discussed, and pursuant to that very judgment, Peshawar High Court has provided video link facility to nook and corner of the province of Khyber Pakhtunkhwa. All the 5 benches, including the principal bench, they are well connected through video links, and till now the High Court has decided 15,000 cases through video link. Likewise, the district judiciary comprising of 35 districts, till date, in last 6 months, they have decided 22,000 cases through video link, while recording evidence while getting assistance of the lawyers from Karachi, from the nook and corner of the entire country. It is also important to note that daily 300 under trial prisoners are attending court proceedings through jail premises via the video link. The under trial prisoners are only appearing before the trial court physically on 2 occasions, at the time of framing of charge and lastly at the time of getting an order from the court after conclusion of the trial. So this facility has been provided, and as I have mentioned that daily 300 prisoners, which has curtailed and minimized the delay in conclusion of the criminal trials. Earlier, as this August gathering is well aware that since 1979, the situation in the entire Pakhtunkhwa is volatile, terrorist-ridden. Therefore, on various occasions, frequently, the police personnel failed to produce the prisoners, under trial prisoners, before the courts due to suicide attacks, due to explosions. That was the reason that this system was introduced, and it is successfully continued. Meanwhile, let me inform this August gathering that total 6,000 cases were disposed of only in district Mardan through video links. So it's a milestone which has been introduced by the High Court Peshawar, and successfully it is still in the field. And even this is important to I would an honor to mention it, that we are getting examination of the witnesses from abroad, from America, from Europe, as well as from the Gulf state. Majority of the citizens, nationals of the KP, they are South people, they are in Gulf states. And if a witness is unable to appear before the court, we have provided one window operation. Any of the party can simply made an application before the trial court. On that very day, it would be processed to the High Court, and the High Court would, next very day, it would take up the matter with the Foreign Office for making an arrangement for the examination of such witness on the date fixed before the trial court. And we remain very, very successful in achieving that very objective of the swift decision of the criminal cases as well as civil suits.